Hello, and welcome to today's episode of Advancing Cyber. I'm Cristin Flynn Goodwin, and I want to talk about a major shift in cybersecurity law that's occurred over the past month. That's the expiration of the Cybersecurity Information Sharing Act of 2015, also known as CISA 2015. If you're listening, you probably know that for the past decade, CISA 2015 has been the backbone of legal protections for sharing cyber threat intelligence between companies and with the federal government. But as of September 30th, those protections are gone. So what does that mean for your organization and your risk posture? Let's break it down. There are four main areas of legal risk that are now in play: loss of legal shields, privacy risks, contracts, and antitrust. First, let's look at the loss of legal shields. And that conversation really starts with looking at liability. Under CISA 2015, if you shared cyber threat indicators or defensive measures with another company or with the government, you were protected from lawsuits generally, provided you followed certain rules that were in the law. That meant the risk of being sued for breach of contract or privacy violations or even antitrust was less. And now those shields are gone. So if you share information and you were invoking CISA 2015 protections, you need to be prepared for the possibility of litigation, especially if something goes wrong. So those general liability concerns that you may have had or your company attorneys may have had 10 years ago are now back in play. And it's time for your company to think about those if that is a major issue for your company when you're thinking about sharing information. The other big issue that was a concern at the time back in 2012, 13, and 14 were privacy and disclosure risks. CISA 2015 also gives clear instructions. Strip out personal information before sharing, and you are protected from privacy law violations. I always found that interesting because it was extremely rare that the teams that I was advising needed data involving PII in a sharing exchange. So this was an extremely rare thing that I needed to invoke, but it was always a nice to have protection. That said, the laws changed significantly in the past decade on the privacy side. And so it's a much more important protection to have now than it was back in 2015. And so with the law expired, you are now operating under a much more important patchwork of privacy regulations. Think CCPA, GDPR, and HIPAA, and more. And so if you are sharing data that contains personally identifiable information, you could be exposed to regulatory action or lawsuits. So that means if you're a threat intel or an incident response team, it's important to get a temporary standard operating procedure in place to manage any indicators that you do need to share that may have PII involved. Hopefully that's not the case, and it's business as usual. But if you do have PII in play, it's a good time to check with your lawyer. If you do have PII in play generally, it's a good time to check with your lawyer anyways to look for ways to reduce that risk, but especially now. And don't forget, as information that's shared with government agencies may now be subject to FOIA or state disclosure laws. So sensitive threat intelligence could become public. And with all of the reputational and operational risks that entails, that's another reason to consult with counsel. When you layer in the privacy risks that are there, it's a really important issue to make sure that you're evaluating with counsel before that information gets shared outside of a company by a threat intel or IR team. So the third main area that comes into play now that CISA 2015 has been suspended is contractual uncertainty. A lot of private sector information and sharing agreements that have been put into place over the past decade reference CISA 2015 for definitions and for its protections. With that law gone, I should say, those agreements may be unstable. And so you might need to review those contracts with your attorneys and make sure that they are still valid and enforceable. Make sure that the confidentiality, liability, and permitted use clauses are still airtight. And if you relied on the CISA 2015 language, you might want to either renegotiate or get some bridging language in place until such time as there's a new piece of legislation that's in place that affords the same protections that we had. Cautiously optimistic we're going to see something come back, but until that happens, now's the time to get some bridging language in place. So what does that mean with this gone from a contractual standpoint? That means that if you've got an agreement with private sector partners that invokes CISA 2015 as a regime for protection, you've got to get a new either contract or bridging language in place for those private sector agreements. Or if you're in an ISAC community that invokes CISA 2015, then you need something in place to protect the ISAC. It's an important consideration. The fourth main area that CISA 2015 protected was antitrust concerns. CISA 2015 made it clear that sharing cyber threat indicators for cybersecurity purposes wasn't a violation of antitrust laws. Without that explicit exemption, sharing information with competitors no longer has that explicit protection in place. To me, the antitrust concern has always been a bit of a red herring. The Department of Justice and the Federal Trade Commission back in 2014 made it pretty clear at the time. And, I'm going to paraphrase a little bit here, but they said back then that the sharing of cyber threat information is highly unlikely to lead to a reduction in competition, and consequently would not be likely to raise antitrust concerns. And I think that's still right. We haven't seen behavior in the information sharing and threat response world that's generally been raising antitrust concerns. But, to be safe, attorneys should be advising their teams to keep information sharing away from that prohibited territory. So keep topics like price fixing, market allocation, and sharing customer lists off the table. And if those topics are kept off the table, you should be fine. So, let's summarize and start to wrap up. We don't know if CISA 2015 is coming back in its current form or in a different version. We're hearing from ONCD Director Sean Cairncross that the White House is looking to bring CISA 2015 back in its full form. That's great. It would be nice to see that happens. It's impossible to guess what Congress will do here, and I don't want to try. There's strong support in industry to bring CISA 2015 back. But until that happens, we still have to make sure that companies and parties sharing information are protected. And the expiration of CISA 2015 in this gap space may chill information sharing if you don't have protections in place. And that's really too bad. ISACs and ISAOs need to be able to respond. They need to be able to act in the event of an incident. Companies need to be able to share information. So think practically. CISA's legal authorities make it an information dissemination body. And so once you share information over to CISA, they have the legal authority to share that widely. Make sure that if you are in a threat intelligence or information response role, that you're working with your counsel to think about what you're sharing with them, because CISA absolutely needs to have critical information to get out to help protect the United States. But you also need to think about how that information is going to be used, because the protections that you had are no longer there. So what should you do right now? First, review your contracts. Make sure that your information sharing agreements have robust confidentiality, liability, and permitted use clauses that stand even if CISA 2015 is no longer in place. Second, if you're in an operational role, talk to your lawyers before sharing threat intelligence or incident response data. Third, remove personal and proprietary information unless it's necessary or unless it's approved by counsel. Fourth, Use secure, trusted sharing platforms with strong governance. 5th, stay on top of regulatory developments. New laws may be coming to replace or supplement CISA 2015. Here's hoping anyways. 6th, document every sharing decision. It's important to keep track of what you decide when your companies are choosing to share information. And 7th, and lastly, keep records of what you've shared, with whom, and under what authority. Because these are different times, these are different rules, and it's important to know what went where and under what circumstances. In closing, we talk about how cybersecurity is a team sport, but at the moment, the rules have changed. And if you're a legal or business leader in this space, now is the time to get proactive. Review your agreements, reassess your risk, and make sure that your organization is ready for this interim space until the rules change again. So this is Cristin Flynn Goodwin for Advancing Cyber saying thanks for listening. Patch your devices, turn on MFA, and keep in touch. If we can help in any way as the rules keep shifting, we're here to help. Thanks so much.